Thank you, Leona. And last and definitely not least is Sam Rieger. Sam Rieger and his wife Wanda became survivors of homicide upon the brutal murder of their beautiful daughter Melanie, who was strangled to death by her boyfriend May 24, 1994. In response to their experiences in the criminal justice system, they have dedicated their lives, and that's apparent from the Melanie Eileen Rieger Conference, which is coming up this May. It'll be the 13th year. They're dedicated their lives to changing the system and helping other people who are walking through the criminal justice system in the aftermath of a crime. Please help me welcome Sam Rieger.
Thank you. I first like to thank Danielle for putting me in this position. It's hard to follow what Leona said. I just don't even know what to say after she said such horrible things in her life. And also to be an addendum in the program. I've never had this happen to me before either. So I'm really batting 1,000, but I really had about 50,000 words to give to you today. So I'm going to have to cut it down because I know you all want to get out of here. And being the last speaker is certainly not an enviable position to be in. As you have already heard, Melanie was murdered on May 24th, 1994. She was strangled to death in our house by her ex-boyfriend. His trial occurred in 1996. He was sentenced to 60 years in prison. 6 weeks after the trial, he was still eligible for good time, so he automatically will get about 1/3 off his sentence just for sitting in prison. I refer to him as inmate number 230602 because he doesn't deserve to be mentioned with a name. He's not human. He's already had many appeals, the latest being before the Supreme Court in February of this year. We're still waiting for a decision. That is his second habeas trial amongst all other appeals. 10 years prior to that, he was before the Connecticut Supreme Court, who denied his motion, and his conviction was upheld. We pray that they will do the same at this point. His first habeas trial was heard in Rockville. All habeas, or most habeas trials, are in Rockville. So if you live in Greenwich or someplace like that, you have to schlep all the way across the state for a habeas trial. The judge's name was White, and I always remember that because he was a black gentleman, so it's easy to remember that his name was White. And he denied the inmate's claim and dismissed the petition. At the trial, inmate number 230602 stated to the judge that just because he had murdered his girlfriend was no reason for him to have to serve 60 years in jail. On January 26, 2004, the habeas court denied the inmate's petition for certification to review its decision, dismissing the petition of the writ of habeas corpus. There have been several appeals since, and we understand that there are already several appeals pending. The question is, when is enough enough? There is no new evidence, and there never will be. The evidence was sufficient to convict him several times over. He has been essentially appealing the same set of facts. When will Wanda and I have some rest from the criminal justice system? Haven't we suffered enough at the hands of inmate number 230602? He chose to take a wonderful, vibrant young lady from society. She had already decided on a career in social work and psychology and was pursuing her studies. She had volunteered at soup kitchens, elderly housing, help with newborns, and many others. What has he done for society? Nothing. Haven't we suffered enough abuse at the hands of the criminal justice system for the supposed rights of this violent criminal? Isn't there anyone with enough guts and fortitude in the criminal justice system or the legislature, and of course there's nobody here listening to this, and they're never here to listen, to stand up and say enough is enough? We found out that there are 30 states in the United States that already have enacted legislation to limit habeas petitions. Connecticut, unfortunately, is not one of them. With the serious financial problems of the state of Connecticut, limiting these ridiculous appeals would save the state a great deal of money. That's what we're trying to do, I guess, is to balance the budget. He is represented by a special public defender from Massachusetts, as the Connecticut public defenders do not wish to take these appeals. Approximately 85% of these habeas cases are handled by special public defenders at additional expense to Connecticut taxpayers, and there are currently over 1,000 cases pending. Beyond these attorneys, you have the additional cost of state's attorneys, judges, various clerks, marshals, transcriptionists, and various other court personnel, not to mention the cost of operating the courthouses and the transportation of inmates, which puts the correction and court staffs at additional risk. I basically testified on this issue before the Judiciary Committee on March 26. Sad to say that bill never made it out of committee. Perhaps it was the impassioned plea of the staff of the Office of the Chief Public Defender. While the Chief State's Attorney's Office and the Connecticut Victim Advocate, Michelle Cruz, spoke in favor of this bill, the public defenders spoke against it. That is certainly their right. However, they made it personal when they researched the details of our case after I had testified and proceeded to begin their testimony trying to refute what I had said. After all, Wanda and I are lowly homicide survivors. What do we know about the criminal justice system? We have only lived the horror of it. They even went so far as to state that inmate number 230602, now listen to this is very important, has suffered almost as much at the hands of the criminal justice system as Melanie had suffered. And it's a good thing that I was not in the courtroom at the time, because I don't know what I would have done. But I don't think they would be walking at the current moment, and I'd probably be in jail. Can you believe that? I thought that testimony on various proposed bills was supposed to be general, not personal. Perhaps the public defenders fear us homicide survivors so much that they have to resort to these tactics. Or are they fearful that their turf may be limited? Only they know the answer. I will not waste my time to research their testimony as they did mine. Why wasn't this bill considered and moved out of committee for the sake of all crime victims who might benefit in the reduction of these worthless appeals and Connecticut taxpayers who might have saved some money in this tough economy? Back in the late 1990s and early 2000s, it seemed like we had begun to make some inroads on victims' rights. I hate to say that I believe that we have regressed considerably since then. What rights did Melanie have when she was brutally murdered? And has anyone cared about the rights Wanda and I should have enjoyed? We will never see Melanie age, get married, have children, provide wonderful support for those less fortunate than she, graduated from college, and various other things. Things we all take for granted were selfishly taken away from us by inmate number 230602. We have further been victimized by the continuance of these ridiculous appeals. We agree that everyone should be guaranteed a fair trial. If they are convicted by the evidence, as in our case and most cases in Connecticut, why should there be so many worthless appeals? Is it unreasonable for crime victims to expect justice for us? Do we have to wait for our deaths or his to finally have relief from the criminal justice system? On behalf of